Let's take a look at a key case in criminal law for the area of loss of control. This is the case of A versus Dawes, which was heard in 2013. In this case, the defendant had returned home and found his estranged wife asleep on the sofa with another man. He started attacking the man and got a vodka bottle and started hitting him with it. The victim then took hold of the bottle and tried to use it in self-defence, but the defendant then got a knife, stabbed the victim and killed him. The defence of loss of control was not available to Mr. Dawes. The judge did not leave it to the jury because the judge decided that Mr. Dawes had incited the violence himself by choosing to go into the property and then start the fight. Mr. Dawes then tried to argue that loss of control should be available and that he was in fear of really serious violence when the victim then picked up the bottle of vodka. The appeal was dismissed and Mr. Dawes was convicted of murder. Loss of control was not available as a defence. The judge did state that even though the defendant incited the violence, that won't always necessarily mean the defence is not available. However, as quoted, one may wonder how often a defendant who is out to incite violence could be said to be in fear of really serious violence. He started the fight in the first place, therefore, how on earth could he argue that he was scared of really serious violence? If that was the case, it wouldn't have woke him up in the first place. The judge then went on to say, similarly, one may wonder how such a defendant would then be able to argue that they had a justifiable sense of being seriously wronged, again, because they started the violence in the first place. This is a really good loss of control case. It is in 2013, so it does cover the law under the new statute from the Coroners and Justice Act. So whenever you have a scenario question where you are discussing loss of control and the triggers, it would be a really good case to show the fear trigger, and there was a lack of fear trigger here, wasn't there, because he didn't get the defence. You could also show it if in the scenario the defendant has incited the violence, because it is likely that that defence will then fail because they've brought that violence on themselves. So really good case for you to use.